It's nice to see your faces and those of you off camera. It's also nice to have you here today. I am going to allow our presenters to introduce themselves, but we have Katherin and Suzanne. Thank you so much for being here and taking your time to really speak on a topic that is near and dear to everyone's hearts that do have employees. So welcome.
Thank you. Thank you so much. We're happy to be here today. And Suzanne and I were talking beforehand about how we really want to make this all about you and what your takeaway is as business founders, business owners, business operators. So we'd love to hear from you in the chat throughout the presentation, but particularly right now, if you could write in what your current role at your organization is, whether it's an operator, founder, if you happen to be in human resources, or perhaps you're just handling HR, even if you don't have that background. And then how many employees you generally have, because some of the employment laws are dependent on how many employees you have. Although I understand many of you, like our organizations, are in significant growth mode. So you may have a certain number under the threshold today, but you're getting ready because you know imminently you'll be at a larger number. And so if you do respond by chat, as appropriate, if Christy sees questions come up, we'll answer as many of them as we can as we go. And just so you know, on the next slide, we're going to show you what we're going to cover today. And as I'm sure many of you know already, being in business, there are so many different issues that you need to be aware of. And, what we're going to do is we've broken them down into 5 different areas. So we'll cover risks related to discrimination and harassment in the workplace, leaves of absence and accommodations, wage and hour issues, risks in the hiring process, and then termination challenges. And so the goal is to get to all of that, but truthfully, if you want to dig deeper through your chat questions in any one of these sessions, we'll take the time to respond and dig deeper there. And then we've offered to come back if the group feels like they'd like to cover additional topics related to employment law or want to dig deeper here. So again, this is all about you. Don't hesitate, ask questions, and we'll kick it off. So,
and Kath, real quick,
yeah.
Should we just say our background really quickly?
Absolutely. Thanks, Suzanne. So Suzanne and I, we were roommates in law school, Boston College Law School, and we have since co-founded 2 businesses together. So we co-founded what's now the largest employment law firm on the East Coast, with the goal of becoming the largest on the West Coast, since we have presence there as well in California. And we do everything from litigate on behalf of some of the largest employers out there, like United Airlines, JP Morgan Chase, Morgan Stanley. And then we also litigate and provide advice and counseling and training and auditing of employment practices to smaller businesses, many of whom are in growth mode. Maybe they have 25, 50 employees, maybe they have 100, 200. And those organizations don't necessarily have in-house counsel, definitely not employment counsel, and they may not even have a sophisticated, experienced HR person. So they team with our law firm and our lawyers to get advice, to make sure they're making the right decisions, they have the right policies in place, they have the right contracts in place. So we really get to team with businesses in that regard. And then we also co-founded 10 years ago, the law firm was 10 years ago, we also co-founded an international e-learning training company that builds courses that are essential to helping employers manage risk. So for example, many states like Illinois, New York, California mandate that employers provide prevention of harassment and discrimination training. And so we build really highly interactive, relevant training in that area, as well as many other areas of compliance and workplace culture. So we, like all of you, have very busy schedules, but we love what we do, and I'm sure you do too. And that's why you're here, to learn more, to protect and grow your businesses. So
if I could just say one more thing, Kath, before you start. Thank you so much for that.
We go back and forth, by the way. Suzanne and I, you'll see, we'll go back and forth, adding, interjecting, and we like it like that.
We joke we're a very good couple together. We've been friends for over 35 years. So just Katherin currently runs the training company, and she really specializes in the training and compliance, and I still do litigation. So we're going to both offer those lenses today, because since we also own 2 businesses, we know what it's like to litigate and have to worry about risk on behalf of our clients. But we also know what it's like to have to do that for our own companies. And so we know that this is a lot for those of you, especially if you're running a smaller company and you don't have internal resources. So really the goal of today is to just kind of highlight the things that if you haven't already, where we would suggest putting a lens on them because they're the areas that create the most risk. So that's how we've identified these. But as Katherin said, if there are other topics that you say, hey, I don't see it on this list, but you want to talk about it, throw it in the chat. And if we have time, we'll get to it. And if not, as Katherin said, we'll come back for round 2 if you'd like us to. So
that's exactly right. And so these are the 5 topics that Suzanne, oh, sorry, prior slide.
Sorry.
These are the 5 topics that Suzanne and I identified as being the most potential for risks for you, where you could get your arms around, get information about them, and then hopefully put processes and practices in place to really protect yourself. So the first on the list was harassment and discrimination issues. And so just treetops, generally speaking, so that you have a good understanding of what is the discrimination that's actually prohibited under federal laws and many state laws. It's discrimination, which is it's behavior that's based on a protected characteristic that results in an adverse employment action. And just as a backdrop, we're talking about federal laws during this presentation today because we know many of you are throughout the country. So you need to be aware that your particular state may have additional laws that you need to be aware of. But generally speaking, the federal laws apply to every single one of you on the call if you're in the United States. So what do I mean by behavior based on protected characteristics that results in an adverse employment action? Well, it means if you as an employer make a decision that is related to protected characteristics. So if you hire somebody and they think it's because of race or pregnancy or color, or you don't hire somebody because of their race, pregnancy, or color, that would be one example. If you promote somebody and they believe that it's because of their religion or their national origin or their age, again, that would be an example of an adverse employment action. So it's only discrimination when you're making decisions based on any one of these protected characteristics up here that results in what they believe to be a negative action. They didn't get a promotion, they didn't get the job, they didn't get the transfer, whatever the case may be. So it's one of those things where you, and we'll talk in a minute as to what you can do. Now that you have this information, how do you make sure you're complying with the law? Well, we'll dive a little bit deeper into how harassment or discrimination may actually show up in your workplace without you knowing it. And the bottom line is what we've seen in our decades of practicing is that if you have a well-run business, if you are operating in a way that you're really trying to build a good culture, the chances of many of these things happening is going to be much lower than if you don't have your eye on the culture or the prize or how people are interacting with one another in the workplace. But one of the most common types of harassment that we see in workplaces is when there's something called hostile work environment. And that's when you have an employee in your workplace and they believe that they're subjected to what's considered unwelcome conduct they don't want to be experiencing based on a protected characteristic. So one of those things we just talked about, race, religion, national origin, etc., that is either so severe or so pervasive that a reasonable person would find that the work environment is hostile. And so what's important to realize is this is not a very difficult standard for an employee to establish because it's the emphasis that I made was on the or. So somebody has to say either there was one comment or one action that was so severe, I don't need a whole history of bad behavior by my colleague to bring a hostile work environment claim. There was one incident that was so severe. I would say in our experience, we don't really see the one severe action or incident as often as we see the pervasive conduct. And by that would include things like offhanded remarks, jokes, slang, things where people might actually have good intentions. They're joking with somebody, they're trying to bring some levity into a conversation, they're trying to establish rapport, but they're crossing the line and they're making comments related to someone's race, religion, pregnancy, national origin. And because perhaps their manager thinks, oh, it's all in good fun, it's good natured, the manager doesn't step in, and the next thing you know, that conduct is pervasive, and then it's a problem because it could be considered the hostile work environment under
And,
the harassment laws.
and Catherine, can I just mention one quick
Yeah.
thing? I would say in the last 15 years, the biggest risk for a lot of your organizations is that everything Catherine just mentioned applies to electronic communications. So text messages, Facebook posts, IMs, people sending each other videos or YouTube videos. So the number of cases that we've seen over the last 10 or 15 years involving inappropriate content that's sent that way, which you wouldn't even know about because you're probably not proactively monitoring your team's messages or your emails. But a lot of times these things can be happening behind the scenes. And so no one's even aware of it except for the people who are engaged in it. So I just want to mention that as well.
Yeah. And that's such a great point, because some people will say, well, I didn't make that comment, that potentially harassing comment, on my LinkedIn, which is associated with my company's name. I made it on my personal Instagram. But what they don't realize is their Instagram followers include some of their colleagues. Or they said, I made it on my personal Facebook page, but their Facebook friends include some of their colleagues. And so all of that could still be considered factors in raising a hostile work environment claim. So, I mean, I think one of the biggest takeaways here for you as employers is to realize you want to make sure you have a rock solid policy that explains what type of harassment, discrimination, and conduct is prohibited in your workplace. And beyond that, we know, unfortunately, many people don't read their policies. Even if you're not in a state that says you must be conducting prevention of harassment and discrimination training, we believe you absolutely should, because everything we're going to cover today, you may or may not know already. Sometimes even human resources leaders aren't aware of all the nitty-gritty details we're going to cover. And you can bet most of your employees and managers aren't aware. And so if they're not aware of what their responsibilities are, they're going to have a really hard time and won't be able to effectuate those responsibilities. So you need the policies, you need the training, because we want to set your leaders and your employees up for success, so you don't have to deal with any of these issues, and you don't have to call us because you need litigation defense. You'd rather avoid these types of issues in the beginning.
Catherine, we do have a question that says, how far can you go in prescribing what people can say or in a policy of what can be said about workplace or team on personal and social?
So how far can you go in terms of like preventing people from saying things on their LinkedIn versus their personal? Well, you want to take a first crack at it, Suzanne?
Well, I think what our policies would normally say, our standard policies would normally say, obviously, if it's anything sent on the company's email communications, is obviously has to comply with all of our policies. But our policies also say that if you engage in off-duty conduct that violates this policy, that you could be subject to discipline up to and including termination. So we can't tell them not to say it unless we're private employers, so the First Amendment doesn't apply to us. If any of you are government employers, then the First Amendment might apply to you. But private employers can say that. Now, there are some states that have really strict off-duty conduct laws, but for the most part, let's say, for example, someone, especially if it's a manager, posted, let's say, a racist comment on their Facebook, we would normally recommend taking serious action against that person, because you can't separate the fact that they said that and they now come into your workplace, and now if they make decisions that somebody accused them of being race-based, that's going to be evidence of, of their animus. So we don't tell them they can't say it, but we tell them that if they do, that there could be consequences, if that helps.
Yeah. And to put an even finer point on it, we will specifically state in the policies, we'll give the examples of where that applies: their personal Instagram, their personal Facebook, their personal TikTok. So employees are on notice that if they cross the line in any of those personal domains, it's still a problem.
Yeah, and along those lines, a lot of people are also surprised to find out that the workplace and these laws apply to the definition of the workplace where these laws apply is very broad. So I will tell you, so many of our lawsuits involve comments or conduct that happens after hours, at a company sponsored dinner, at a sales conference, or at a dinner after a sales conference. So anywhere where your employees are interacting, if they were to engage in inappropriate conduct, that could subject your organization to legal liability, which is shocking, but that's the reality under the current state of the law.
And again, not what everybody expects if they're not employment lawyers or HR. And that's why it's so important to put it into the policy and to train people on it so that they know what the workplace includes. This is an important aspect of the harassment laws too. So the prevention of harassment discrimination laws strictly prohibit retaliation. And actually, if you look at the number of complaints that are filed every year, either with the EEOC or in court, the largest percentage is employees claiming I was retaliated against by my employer. And so retaliation, generally speaking, it's again, any adverse employment action, right? Failure to hire, firing, failure to give a promotion, any retaliation taken against an employee in response to that employee's complaint. So it can be an employee who says, look, I'm feeling uncomfortable because these conversations are being made in front of me and I think they tie into my pregnancy. And if that employee complains to anyone in leadership at the organization, and then that employee is subsequently terminated, passed over for a promotion, anything else, that opens the door for them to claim, I complained and then I experienced this adverse employment action. And I think there's a correlation between my protected category and the fact that I complained. So it's one of the reasons why you really have to act and follow protocol when an employee brings a complaint to your attention. And Suzanne does a ton of investigations into employee complaints. And then we advise employers as to how to handle them so that they avoid these claims of retaliation.
Yeah, I'm actually serving right now as an expert witness in a lawsuit where I'm analyzing the company's investigation and opining on whether or not I think they did it properly, because that's another legal obligation you have, that if somebody does raise a complaint of alleged harassment or discrimination or legally prohibited retaliation, you as an organization have an affirmative obligation to promptly investigate it and then to take steps to address the harassment. So just one of the many other obligations that's put onto employers.
Right.
So that kind of goes into what Katherine's going to talk about here.
Exactly. So really the key takeaway, if you're taking notes, is really think about, or what can I do to contain this potential risk or avoid this potential risk, right? Well, under the law, you want to first do whatever you can to prevent the harassment so that someone can't say you were negligent in performing your duties to prevent harassment and discrimination. So that could be everything from having that detailed policy that Suzanne and I spoke about, making sure everybody gets a copy of it, everybody signs off on it. I know some companies have the founder or the CEO recirculate that policy every year and require signature so that it's front and center in people's minds. Again, you want to either internally or externally train your workforce, especially your managers who are responsible for preventing the harassment and discrimination, on their obligations under these laws. If you're in a mandated state, you have no choice. So you'll be fined and be subject to penalties. Even if you're not in a mandated state, you don't want to be negligent in fulfilling your duties. So you want to make sure you educate your team members. Plus, we all know we're not just doing this for risk containment, right? We're doing it because we want the best possible workforces. We want to be the go-to company so that when we're out recruiting candidates, people want to come to us because they know we have a great culture and we don't allow harassment or discrimination to persist within our walls. So you want to do whatever you can to prevent the harassment from occurring. If you hear of any complaint regarding harassment, discrimination, retaliation, you want to immediately stop it. And you can stop it by, one, engaging in an investigation. And if you don't know how to conduct an investigation, you want to make sure you get an expert, a very experienced person who does, because whoever investigates is going to be the number one witness at a harassment discrimination trial. In many instances, like Suzanne is going to be testifying at trial that the company that hired her did all the right things and thoroughly investigated the complaint. So you want to make sure you stop the conduct, you conduct an investigation to determine what's going on, and then you want to implement what we call remedial action. If you determine that there was improper behavior, you need to decide what is going to stop the harassment and make sure it doesn't happen again. And sometimes that's difficult to do. Like, we'll have employers who come to us and they say, we have this top sales producer. And yeah, there have been people who have been complaining about their conduct, but we don't want to lose this person. But we know we have an obligation under the law to stop this conduct from occurring. What do we do? And that's like, that's the huge question. Is it enough to give that person a warning? Do you have to impact their pay in some way? Do you have to terminate them because you're not confident that impacting their pay or giving them a warning is going to stop the conduct? You just need to figure out what is going to get the job done so that you don't have additional complaints coming in about that particular individual.
And then one last thing on that, a lot of people think that you have to receive a formal complaint, something in writing, or they have to go to the head of the company. That unfortunately is not the case under the law. So if any of your supervisors become aware of potential discriminatory or harassing conduct or potential illegal retaliation, and they do not escalate it to the company, that person can be individually liable and the company can be liable. So that's again where the training and the policies really come into play.
Yeah, that's another great point. I mean, I like to refer to it as, if you as a manager in an organization know or should have known that there's conduct going on that could be creating a hostile work environment, you have an obligation to act. So that's a really tough standard, right? I should have known because I heard scuttlebutt, I heard gossip, even though nobody came to me to complain. That's enough to potentially trigger your responsibilities. So we're not going to go into these in detail, but suffice it to say that employees can collect on many different accounts if they believe they've been harassed in the workplace.
Yeah, and that's probably 75% of the lawsuits that we defend are harassment, discrimination, and retaliation claims. So that's why we spend a little bit more time on that section. We're going to kind of breeze through the others. So I wanted to talk a little bit now about kind of some of the hidden risks where you have an employee who needs time off from work or who asks you for some kind of a work modification. One of the most common we've seen ever since COVID is people asking, if you have an in-office policy, asking to be hybrid or be remote. So I looked at the chat and it seems like potentially only one of you are covered by the FMLA. But let me quickly just talk about the FMLA. So there are several federal laws that impact leaves of absence and accommodations. And these are the laws that by statute grant employees the legal right to take time off. And they have very technical requirements. So for the FMLA, which would entitle employees to take up to 12 weeks of unpaid leave with their same health benefits in a 12-month period for certain reasons, like the birth or adoption of a child, to care for their spouse, child, or parent with a serious health condition, to care for their own health condition. That law only applies, this federal law, if you have 50 or more employees within a 75-mile radius. So I think there's one person who said they have 100 employees over 4 companies. So it's just even being covered by this law is technical. That said, I will tell you that if you're not covered by the FMLA, that doesn't mean you're out of the woods, because unfortunately, many states have their own leave laws. So for example, our law firm is headquartered in New Jersey, and in New Jersey, we have the New Jersey Family Leave Act, which also requires 12 weeks of leave by statute. Again, it's unpaid leave, although we do have a leave insurance in New Jersey that doesn't give employees some pay, but the statutory obligation is only to give 12 weeks of unpaid leave. The threshold in New Jersey is 30 employees, and it is going to 15 employees in July of 2026. And that is the trend we're seeing. The state laws tend to be much more employee friendly than the federal laws, and the trend is more and more and more coverage. And just also one quick FYI, the discrimination laws that Katherin was talking about in the first section, primarily the federal law is Title 7. That's triggered when you have 15 or more employees. But again, the state discrimination statutes are usually less. In New Jersey, if you have 1 or more employees, you are covered by the New Jersey Law Against Discrimination, which gives all those protections that Katherin mentioned in the first section. And as I was saying earlier, most of the blue states have their own employment discrimination laws and very low thresholds. So you should definitely make sure that whoever's in charge of human resources and compliance at your company has a good understanding of which of the leave laws apply to you. And if anybody has any questions about their state, feel free to, message me offline and I can let you know very quickly what the threshold is. I want to talk a little bit about the Americans with Disabilities Act. For those of you who don't know, that kicks in if you have 15 or more employees, and that's a federal law that requires all employers who are covered. So if you have 15 or more employees, you are required to engage in an interactive process with any of your employees who request an accommodation for a disability. Now, a disability is the threshold is very low. I will tell you, it's anybody with any kind of a chronic physical condition. It's also anybody with a chronic mental health condition. So the definition is very broad. So my advice is anytime any employee comes to you and says, I need time off, I need a work modification, I need to work from home because I have a fill in the blank, medical condition or mental health condition, if you are covered by the ADA or a state law, because our state law requires the same thing as the ADA, you're required to engage in an interactive process with them and to make reasonable accommodations for them that will help them do their job, so long as it doesn't cause an undue hardship on you.
And I would just add that this is a really complicated area.
Yeah.
Like when Suzanne says you need to have that interactive conversation. So if it's the first time or even second or third time you're dealing with this, I highly recommend you reach out to either HR or employment law counsel to walk you through it, because it's important to, one, have that conversation appropriately. And there's certain things you can ask and not ask. And two, it's really important to document the fact that you had that conversation. So if you don't have an HR background, it's going to be hard to get that exactly right without that counsel until you got the hang of it.
Yeah, and that's a great point. And a lot of our lawsuits where there's an issue with there's an allegation of disability discrimination by an employee, it usually comes up in the scenario where somebody goes and says, hey, I need time off for let's say a surgical procedure, which would definitely be considered a disability. And the company says, well, we're not covered by the FMLA, so we don't have to give you that time off. Unfortunately, under the Americans with Disabilities Act, you would absolutely be required to give them a reasonable leave of absence. That's by law considered a reasonable accommodation. So that's where these laws get tricky. I think a lot of small and mid-sized companies just assume, oh, well, we're not covered by the FMLA, so we're not required to give time off. But unfortunately, you probably are under either a different federal or a different state law. And the other one I also want to mention, because obviously anyone that employs, women who are of childbearing age, you probably get a lot of requests for time off for pregnancy. And again, a lot of people think not covered by the FMLA, so I don't have to give them time off. Well, under the ADA, if they have pregnancy complications or they go have the baby, they would be entitled to a leave as an accommodation. But there's also something called the Pregnant Workers Fairness Act, which is a federal law that applies to you if you have 15 or more employees. And that requires all employers of that size to provide reasonable accommodations to not only an employee, but even to an applicant who is pregnant for their pregnancy or any childbirth related complications, again, unless it would cause an undue hardship.
And from a workplace morale standpoint, it's really important to have a good understanding of these laws, because the last thing somebody who has a disability wants to do, or someone who's pregnant wants to do, is to have to really fight and advocate for leave that they're entitled to under the law. They want to feel like their employer knows what their responsibilities are and supports them. And so, of course, is going to do what they need to do to accommodate that employee. So what we sometimes see is an employer will resist, and then realize they're wrong. And then all of a sudden they have a disgruntled employee who's wondering why their employer resisted doing what was legally required under the law to begin with. So I know so many of you on the call are altruistic, as well as, wanting to operate really successful companies. And I think they go hand in hand, really growing workplace culture and also protecting yourself from legal risk.
Yes, and it is tricky. We understand when you run a company where you don't have in-house resources, but to Catherine's point, our recommendation of best practice is to make sure that there's someone in your organization who your employees know who that person is, that they would come to if they have, let's say, an accommodation request, or pregnancy related issue, or even, a discrimination or harassment issue. Because ultimately you want your internal resource to be informed about what laws do apply, what types of leave employees are going to be able to take. And then also in a lot of states, like New Jersey, again, for example, in addition to having obligations to provide unpaid leave where you have to hold their job, we have a short-term disability program, and we have a New Jersey family leave insurance, and people are looking to you as the employer to be their resource to provide that information. So it's a lot. And then this is just very similar to what I mentioned earlier about, a complaint about discrimination or harassment. It does not have to be formal. So if somebody comes and just says that, they need time off due to pregnancy, or they need time off to go to the hospital with their child, they do not have to use any magic language. So they don't need to say, I'm asking for FMLA leave, or they don't have to say, I'm making a request for a reasonable accommodation. Basically the message to your team is, if anybody comes and says, I need time off for anything related to their medical condition, their family's medical condition, a pregnancy, or they need a change to their workplace, that needs to be escalated to whoever the person is at your company that handles that. So if you have a dedicated HR person, it would be them. And if you don't, you need to figure out who internally they should go to so that that person can gather the necessary resources to respond.
And I would just recommend, because this is complicated information. Whoever that designated person is, they should have a relationship with either an employment law attorney or an HR consultant. Like we work with many companies who we're their first call. We're speed dial. They'll say, I have somebody who came to me and asked this. What do I need to do to communicate with them to document? Obviously, it doesn't need to be us, but it should be somebody who you trust, who will point that person in charge in the right direction and give them all the information they need to effectuate their duties.
And this just reinforces what I mentioned. We don't want your frontline employee managers or supervisors assessing or evaluating. So we certainly don't want them asking questions about somebody's private medical information or writing down or asking for documents. So all of those things create risk for your company. So the idea is that you let your supervisors know if anybody brings a request to you. You say, thank you very much. I'll escalate it and I'll connect you with them. They should not be asking any follow-up questions. I have cases all the time where managers take it on themselves to sit down and have a long conversation about somebody's medical information or ask for documents. And all of that is treated as confidential and should only be provided or requested and provided to the senior level person at your company who's handling HR.
So those are the things that would go right into your training on FMLA or ADA, whatever the case may be, like what managers do. I always say HR or whoever is handling that becomes their best friend because they need to be.
Because I can almost guarantee you I mean, this is our job full time and it's hard to keep up on. So there's no way that somebody that receives one of those requests would know any of these things. Okay, so moving to our next topic, I want to talk really quickly just about some wage and hour issues. Again, I'm going to do treetops here because I know I could spend 8 hours talking about issues with wage and hour law, but the reason we include this is because these laws are so technical, they are so easy to violate. Frankly, most companies violate them because they have no idea that they exist, and the potential risk on the back end is enormous, because if you're misclassifying somebody as, exempt, who's not exempt, or you're misclassifying somebody as an independent contractor who's really an employee, our law firm routinely gets involved in audits by the federal Department of Labor, by the state Department of Labor. And then also, this is a very hot area for plaintiffs' lawyers to bring class action lawsuits against companies where they represent all of your employees who are being impacted by this. And that's where, just in terms of the 6-figure exposure, it's a significant area of risk for your company. So what I just want to talk about, just again, very generally, is exempt versus non-exempt, because this is something that a lot of people don't understand, and it can get you into a lot of trouble if you're not properly classifying people. And then I want to talk a little bit about the risk of misclassifying somebody as a 1099 or an independent contractor versus an employee. I'm going to focus, again, primarily on the federal law. That is the Fair Labor Standards Act, the FLSA, if you haven't heard of that before. And unfortunately, the FLSA covers almost every employer. You just have to have a certain revenue threshold, and then you're covered. So what I'm about to talk about now, 99% of you are going to be covered by these laws. And again, I'm going to talk about the federal laws. Some states track the federal law very closely. New Jersey is almost identical. Other states differ. 99.9% of the time, if your state has its own wage and hour laws, they're going to be far more pro-employee than what I'm about to talk about. So I will give you an example. California, if any of you operate in California, it is truly, that's where Katherin is, the wild, wild west. And things like overtime, for example, I'm going to talk about, under federal law, you pay overtime if somebody works more than 40 hours in a week. In California, you pay overtime if they work more than 8 hours in a day. So if you don't know what your state laws are, you can just create a lot of risk for yourself. So you really, and also in California and other states, some municipalities have their own wage and hour laws, including their own minimum wage. So this is just a really ticky-tacky, difficult area. So I'm going to talk high level. And again, I'm happy to talk to any of you offline if anybody gets scared by any of this, because this is an area where if you're going to focus, this is the place to focus.
Yes, definitely.
Yeah. So just as a general rule, a lot of people are not aware that every single employee in your organization, yourself included, if you're getting paid by your organization, you must be classified as either exempt or non-exempt. And that should happen before someone is hired. Kat's going to talk a little bit about hiring do's and don'ts. A big hiring do is that you say that you issue a written offer letter, and you say in the offer letter whether the employee is going to be exempt or non-exempt. The reason that this distinction is so critical pre-hire is that it is going to dictate how the individual keeps track of their time and how they are paid. And as I am about to review, there are significant differences in how exempt employees and non-exempt employees should be paid. So high level, exempt employees, which we'll talk about how you can make somebody exempt, because unfortunately you can't just make them exempt. There are tests, which we'll talk about in a minute. But if somebody's exempt, they get paid a salary, basically the same amount every week. I'll talk about what that threshold is, and they are not eligible for overtime. So I'll give you a perfect example. Lawyers fall under one of the exemptions, professional exemptions. So anyone who works at my office as a lawyer, they are classified as exempt as long as I pay them a salary, and they can work 100 hours in a week and they're not entitled to overtime. They get a salary. On the flip side, non-exempt employees are typically paid hourly and they are eligible for overtime. So in my office, a perfect example in our law office would be our receptionist. She does not fall into any exemption. And so she needs to record her time and she needs to get paid for every hour. And in New Jersey, if she works over 40 hours in a week, she gets overtime. We have a California office. In our California office, if they work more than 8 hours in a day, they get paid overtime. Okay, so how does somebody become exempt? Because a lot of times people will call me and say, well, I pay this person a salary, so they're exempt. And I say, unfortunately, that's only one part of the test. They have to get paid a salary, and there's a threshold, which I'll talk about on the next slide. But before we even get to that, you have to determine if they fit into one of these categories. And again, these are the federal categories. So an employee can only be considered exempt if their primary duties, think of that about it's like, what are they doing most of the time, 51% of the time or more, fit into one of these categories. And again, this could be an 8-hour session, but there's the professional exemption, which again is like lawyers, doctors, teachers, accountants. The administrative exemption, which is the squishiest, that's the one where everybody tries to fit people in, but it's harder than it looks. They have to exercise significant discretion and control. So it would be an example of like a chief operating officer at a company would almost certainly fall into the administrative exemption. The executive exemption is the other biggie. These are the three biggies: the professional, the administrative, and the executive. They're the three most common. The executive exemption is that you have to be a manager. Your primary duty has to be that you manage 2 or more people. And so that's where you can put some of your supervisors and managers into the exemptions. Then there are these other ones that are more specialized: inside commission sales, outside sales, and computer. And then the highly comped, they have to be doing, let's say, white collar duties. That's how the FLSA defines it. And they can be exempt if they're, right now, the threshold for highly comped is if they make $107,432 a year or more. There's an exemption just for highly comped employees. Okay. Then if they meet one of those tests, if they fall into one of those buckets, they still, in order to be exempt, they have to get paid on what the law says is a salary basis. And here I've included the definition. They get a predetermined amount each pay period, weekly or less frequently. And you cannot make, and this is where a lot of people go wrong, you cannot make any partial week deductions. So if an exempt employee misses a day of work, they still get their full salary for that week. You can apply PTO, but you can't make deductions from their salary. The salary threshold test changes. It's only $35,568 a year right now, or $684 a week. Again, this is under federal law. You have to check your state law, because odds are, if you're in a blue state, it's probably higher. And so if somebody's getting remember, they have to fall into one of, oops, wrong way, sorry. They have to fall into one of these buckets. If they fall into one of these buckets and they're paid a salary of at least this amount, the 107 that I mentioned is for the highly comped, then you can most likely deem them to be exempt. Any questions about that?
So my question is, what are we
Yeah.
recommending to them? Because I'm sure your heads are spinning right now, right? There's so much to know. Like, you have employees coming on board, or employees you already have, how to determine whether or not you've got people correctly classified, or if you're at risk. And so really what we often do is we'll go in and we'll audit companies' wage and hour practices if they're not sure, before somebody goes and files a complaint with the wage and hour division. And we'll tell them that these people are correctly classified, these aren't. Sometimes companies will call us when they're bringing somebody on and say, how should I categorize this person? Are they exempt? Are they non-exempt? So we don't expect you to memorize and be able to perfectly apply all of this, but we definitely recommend that, again, you get advice if you don't think you're complying, and seek help so you reduce your risk.
Yes, and the biggest risk is for people that you've classified as exempt who aren't, because if they're not keeping track of their time and they're not getting overtime, that's where your issues come in. And we'll talk about all that in just one more minute. I also want to mention job descriptions, because a lot of times clients will say to me, well, look, my job description says they're exempt. I'll say their job title makes them exempt. And so we always say job title, job description does not automatically create exempt status. You do have to look at what the actual primary duties are, but we do say, where you think somebody's legitimately exempt, write the job description, if you have them, in a way that reflects, what mirrors the exemption criteria. And then I just want to go through in just a little bit more detail. We talked about if you are legitimately exempt, you don't have to be paid overtime. However, if you are non-exempt, if you don't fit into any of those exemptions and you're not paid a salary, then here's what you have to make sure your organization is doing. Number one, the employee has to be paid the applicable minimum wage. Now, the federal minimum wage, shockingly, is still $7.25 an hour. No state where my clients tend to operate, very few states where my clients tend to operate, there are some, are that low. Most of the states are significantly higher. Just by way of example, Colorado, which I know where our wonderful hosts are, $15.16 an hour. California, $16.90 an hour. New Jersey, $15.92 an hour. So just make sure you know the minimum wage in your state and your local municipality if you're in a city that has its own minimum wage. Now, the most important thing, because a lot of people are already getting minimum wage, if an employee works more, again, this is the federal law, more than 40 hours in a work week, they have to be paid overtime. And that is 1.5 times their regular rate of pay for anything over 40. So if they're paid $20 an hour and they work an extra 10 hours, then for those extra 10 hours, they need to be paid time and a half the 20. So they need to be paid $30 an hour for those hours that are over. And unfortunately, especially in states like California, they broadly define the regular rate. So if you have employees that are getting, like piecework or any like small bonuses, that might have to be factored in. So this is where it gets very technical. The other mistake that most companies make when we start working with them is that they're not even having their non-exempt employees track their time. Now, by the law, companies are required to have all of their non-exempt employees keep track of their time. There's 1,000 ways you can do it, but I'm going to tell you the risk is if they're not keeping track of their time, since the company is obligated to do it, the Department of Labor or a court will say, employee, since you weren't keeping track of since your company didn't make you keep track of your time, you tell me how many hours a week were you working. So if they say that they're working 100 hours a week and you have no way to disprove it through some timekeeping mechanism, they can potentially get paid overtime for hours that they weren't actually working. So that's the most important takeaway from this part of the presentation is non-exempt employees must keep track of their time, ideally on a weekly basis.
And Suzanne's not kidding. Like, we've been at wage and hour hearings where an employee comes in with a napkin, like jotting down the extra hours they worked. And the wage and hour commissioner will say, okay, that will hold because your employer can't disprove it.
Suzanne, there is a question, and Maria, if you want to clarify your question, it says, I have a professional employee who has a base rate that does not meet the threshold, but with their typical weekly caseload, we're talking about as probably a psychologist here,
Right.
they will
Yes.
meet the threshold most
Yeah.
weeks, non-vacation weeks.
Yes. So if I'm reading the question correctly, I think the answer is not going to be a good one for you because under the law, they have to be guaranteed a minimum of the $684 every single week. So there might be a way to restructure the pay so that you can do that. But if they're not getting a consistent salary that meets the threshold every week, then the employee would automatically be deemed non-exempt, unfortunately.
Thank you.
And people have put in some good suggestions for time tracking, which is great. I'm sorry, did somebody have a question or a
Yeah,
follow-up?
it's Aggie here. Let me know
Yeah.
if this is wrong, but I believe that with professional licenses, clinicians are automatically non-exempt, or there is something that I read about the fact that when a clinician or somebody has a professional license, they are non-exempt by nature. Just want to validate that.
Yeah, so a clinician, if they're a therapist, et cetera, they probably fall into the professional exemption. But as I mentioned, it's do they fall into an exemption and do they get paid on a salary basis? And you have to meet both. And so if you don't meet both, the exemption's destroyed. So they'd have to be, so even a lawyer, if I don't pay my lawyers at least $684 a week under federal law, they would technically be deemed non-exempt. Now, it only becomes an issue if they're working overtime. As long as you're paying the minimum wage, your risk is low if they're not going over 40 hours a week. But where the risk comes in, if you think they're exempt and they're not, you're probably not having them keep track of their time. If they're keeping track of their time and they're working less than 40 hours a week and you're paying them at least minimum wage, your risk is fairly low. Does that make sense from a
Thank you for that.
practical
Yeah,
standpoint?
totally.
Okay. So very quickly, I just want to talk about independent contractor misclassification because this is a big. And almost every company uses people that they deem independent contractors. They're not really independent contractors under the law. So I just want to highlight this as a big risk area.
Especially here in this audience, right? Where everyone's in growth mode and lots of times growth mode companies are using contractors.
Exactly. I mean, we did it when we started in the very beginning, and then we immediately stopped once we realized the risk. Because I will just say, if you're issuing 1099s, you are red flagged for an audit, and that doesn't mean you're going to get audited. But if you do get audited, having been through probably 100 or more of these on behalf of clients, the departments of labor, they want to find that everyone is an employee, because what that means for them is that it generates revenue, it generates tax income, it generates unemployment, it generates Medicare, it generates Social Security taxes. So the presumption going in, as I wrote here, is that they're going to come in to any audit or any claim that with the presumption that the person is an employee unless you can prove otherwise. And having been through this so many times, even where I think there's a legitimate classification, sometimes we lose. So it's just an area where if you're going to do it, just know that you're assuming some risk.
And it's like shooting fish in a barrel going after small employers, right? Because it's so hard for small employers to keep up with these technical rules when you don't have an HR leader or an employment lawyer. So don't think you're gonna fly underneath the radar because you're small. You're probably a more likely target because they think that they're going to be able to catch you.
That's an excellent point. And actually, Chrissy just put in the chat that she's already had 3 clients audited this year, which is incredible. And I will tell you, I had a client that they own laundromats and they were small and they thought that they could just skirt by, and they've been audited on everything. The independent contractor, their I-9s, and they're a tiny company, but they've been assessed a ton of penalties. Here I just have a chart. This is the ideal contractor. They're very hard to find. But the bigs are if they are a separate company, they have their own employee identification number, they have their own workers' comp insurance, they have their own other insurances, they own their own equipment, you're not directing or controlling them. You kind of have to meet all of the things on this chart, and to do so is extremely difficult. So this is an area where if anybody wants to talk offline, I am more than happy to talk with you about it. But it is very hard to get somebody classified as an independent contractor on a 1099. Like vendors that you're paying, if somebody's doing painting for you or they're doing maintenance for you and you're paying their company, that's not who I'm talking about. I'm talking about people that you're bringing on and they're in your office and they're doing similar work to other people in your office. High probability that they're being misclassified. And the risk of misclassification, as again, we won't go through it in detail, but the biggies are They could have you could have overtime obligations for them. They're not keeping track of their hours possibly, so they could have a lot of overtime. There's big penalties. You could have workers' comp insurance, unemployment insurance, Social Security, and then you could have retroactive bonuses or 401k contributions for them or health benefits, et cetera. So it's just a risky proposition. All right. I know we still have a lot to get through, Kat.
Right. Okay.
Zoom
5
along.
minutes. So we'll again cover the main issue. So when you're hiring, there are a number of things that you need to keep in mind. One, the discrimination claims. You want to make sure you're not hiring somebody because of their race, their religion, national origin, et cetera. There are also requirements that you put certain information, as Suzanne mentioned earlier, into offer letters, and many states mandate that information be in an offer letter. So you have to, we recommend starting with the template that complies with your state's requirements and then using that each and every time. And then you want to do whatever you can to make sure you really maintain that at-will employment relationship to the extent it really exists. And we'll talk about that in a second. So starting with the interview process, and this is an area where, again, unless you've got HR leaders on your team, people aren't necessarily going to know what questions can they ask, what can't they ask. These laws change regularly. So I absolutely recommend you go through some type of interviewing training for anybody at your organization who's doing the interviewing, whether it's just you as the founder or operator, or whether it's others, because there are questions that would definitely be considered illegal. So it would be, of course, legal to ask about someone's education, where they went to school, what they studied, where they worked, why they left. But you wouldn't want to ask anything that reveals their protected category. And sometimes that comes up through conversation. Like someone may come into your office and they may see pictures of your family and break the ice with you. And you might respond and say, oh yeah, how about you? Are you married? Do you have children? And point blank, you just asked 2 illegal questions. You don't want to hone in on whether somebody has children, and in some states, what their marital status is. So many of these questions are not necessarily intuitive. Again, some of the good ones are asking questions to clarify their application, asking questions related to their ability to do the job, gaps of employment, really gauging their interest in your company. How well did they research you? But more importantly, the don'ts on the next page are asking questions which could solicit responses that are problematic, related to their race, age, national origin, etc. Some just good ones. I think I just want to hone in on for 1 minute that you'd want to incorporate it. And truthfully, you can do some probably chat GPT searches to come up with some really good questions you can ask. Although Suzanne and I always say, definitely run those by an employment lawyer, because sometimes chat GPT will hallucinate and point you in the right direction. But some good ones are, what kind of references would your former employer give us if we call them? Right? That's a good one. Or what did you like about your prior job and dislike about your prior job? And then we also like, what's a challenge that you faced at your prior job that you were able to establish a workaround? So, hiring, you can have a lot of fun with hiring. And truthfully, as employment lawyers, we believe so much more time should be put in on the front end to hire the right person for the position, to hire the person who you believe can grow within the organization. Because once somebody's on board, it's very difficult to terminate them without legal risk. So put the time in on the front end and top grade and get the best possible hires in place. For your offer letter, again, you want to check your state law to make sure you comply with it to a T. But here are some of the things you want to include. One, you always want to include at-will employment language. And sometimes I have employers push back and say, but that sounds so sterile and unfriendly, and that's not consistent with our culture. Well, bottom line is, if you want to be able to maintain that at-will employment relationship, it needs to be in the offer letter, and it needs to be stated, point blank. So you can have other warm language in the offer letter, but you really need to have the rote at-will employment language that an employment lawyer can give you to put into that letter. As Suzanne mentioned, you definitely want to specify whether they're exempt or non-exempt, whether they get overtime or not, the timing of their payments, when they'll be paid. You want to specify other requirements like a background check and that kind of thing. If there are other agreements that they need to agree to through the employment. You want to include that as well. And then we think it's a good idea to include a job description, but I also view job descriptions as living, breathing documents. And I think oftentimes the job description you give them when they start may not even be the job description that they're performing a couple months in, once you see what additional capabilities they have or what you don't need them to do. So it's important to kind of keep that in mind and update it as you go, right?
So since we're at 12:59, I want to be respectful of everyone's time. So Kathy, I think we should just skip this last section,
Yes.
which is all the things that can go wrong when you fire somebody,
Yeah.
and just give you, this is our summary slide of best
Yes.
practice tips.
Yeah.
We talked about almost all of them, but the big one I want to tell everybody about, because I feel like if you take nothing else away from today, and hopefully you do, last lines of defense, employment practices liability insurance, EPLI. So I mentioned that. Thanks, Aggie, because all the risks that Catherine and I are talking about, they are, I've been a litigator for over 30 years, and I will say, knock wood, I've never lost at trial. Where my clients lose is that they have to pay my law firm, our law firm. They have to pay us a significant amount of money to defend them in these claims. And even if we win at the end, they do not ever get those fees back. It's a very one-sided system. So with EPLI insurance, you want to make sure that you work with somebody that's very knowledgeable. You want to make sure that your policy limit's high enough. I'm not an insurance professional, but when people ask me, I say do at least 2 million, because you'd be shocked at how quickly you can go through legal fees. You can get a high deductible, but make sure it includes your legal fees, because that way, if somebody files a lawsuit against you, brings a charge, writes an attorney demand letter, you at least have the backstop of having insurance that could potentially pay your legal fees.
And so I view that, as Suzanne pointed out, the last line of defense. I think the first line of defense is making sure you have trusted counsel to help you prevent these issues to begin with. Because once you get sued, even if you have coverage under EPLI, you might have brand reputational damage, morale damage, all that sort of thing. So if you're trying to do the right things to begin with, hopefully we or somebody else can help you keep out of trouble and keep compliant and keep focusing on growing your business positively and productively. And you'll decrease your chances of needing to have us or anybody else defend you down the road. And that's it in a nutshell. So if there's anything else you want to hear more about next time, just let Aggie or Christy know. And otherwise, we wish you all the best of luck. We know it's not easy being you, and we respect and honor you for that.
Thank you so much for your time and information today. I know it was a lot of information. We will have a recording to this that we will send as a follow-up in case you have things you want to dig back into. And as long as they are okay with it, I'd love to include their contact information in that email as well, so that you can reach out with your direct questions. But yes, thank you so much.
All.
Thank you. Have a great day, everybody.
Christy and Aggie, thanks for having us.
Hey, it's our pleasure.
Have a great day.
Thanks.
Bye.
You too. Bye.